buenos días a todos. Bienvenidos a esta tercera mesa. Ha habido una notable alteración, como ven no soy Luigi y hemos pasado la mesa de las 3 de la tarde a esta hora. Esta mesa tiene la particularidad de que los ponentes van a presentar los dos proyectos, dos propuestas de convenciones internacionales sobre el delito de ecocidio y sobre criminalidad medioambiental. En ese sentido es absolutamente novedoso y ellos vienen a presentar lo que un equipo de trabajo, sobre todo de personas vinculadas a universidades de Francia, Italia, Estados Unidos, Brasil, Luxemburgo, pues han estado trabajando en materia de, ya digo, convenciones internacionales para regular estos delitos. El equipo lo ha liderado el profesor Logan Negué y ha participado también pues, nuestro querido Adán Nieto, ¿no? En ese sentido es un lujo poder contar contigo de primera mano, donde nos podrás ilustrar mucho de cuáles han sido las vicisitudes que habéis encontrado en el camino y qué propuestas concretas habéis alcanzado. Bueno, me acompañan en la mesa el doctor Marco Colacurci, que nace en Nápoles en 1989, lo digo porque es un joven profesor. Él, desde el año 2013, pues, ha trabajado sobre temas de internacionalización, de sistemas legales, derechos fundamentales y trabaja actualmente en la Universitá de la Campania junto al profesor Stefano Manacorda. Es un experto en criminalidad empresarial, responsabilidad del Estado por ecocidio y crímenes medioambientales y en ese sentido, pues muchísimas gracias, Marco, por acompañarnos esta mañana. A mi derecha, pues como saben ustedes, está el profesor Adán Nieto, co-IP de este magnífico proyecto de investigación del MINECO, responsabilidad penal de las empresas multinacionales por violaciones de derechos humanos y del medio ambiente. No olvidemos que ese carácter bifronte es lo que inspira este proyecto de investigación, en el que tengo también el gusto de participar como investigadora. Pues decía, Adán Nieto, como saben, es catedrático de Derecho Penal en la Universidad de Castilla-La Mancha, subdirector del Instituto de Derecho Penal Europeo Internacional, es el máximo especialista en temas de corporate compliance y el sector público. Tiene una monografía en 2015 que obtuvo el premio de Ciencias Sociales, es director del curso de posgrado de Corporate Compliance, en fin, pues como saben, es un grandísimo experto en estos temas y ahora también forma parte, como he dicho, del grupo de trabajo que, liderados por Negué, pues ha presentado estas dos convenciones. Podemos entonces abrir el magnífico libro que ha editado Marta Muñoz de Morales, que me parece un lujo, con este cuidado con lo que lo has hecho, Marta. Tenemos las dos convenciones internacionales a nuestra disposición. Abrámosla y, desde luego, espero y confío en que tengamos después oportunidad de dar paso a un agitado debate. Las dos convenciones internacionales que se presentan aquí tienen contenido penal, no son convenciones al uso. En ese sentido, yo creo que se enmarcan ambas dos en el puro derecho penal internacional, en el sentido de que, si bien las fuentes tienen que ver con el derecho internacional, el contenido va a definir muy claramente, con mucha seguridad jurídica, cuáles son los crímenes de medio ambiente y cuál es el crimen de ecocidio, cuáles son las reglas de cooperación internacional, qué sanciones se pueden imponer a personas físicas y a personas jurídicas. Incluso en relación con el crimen de ecocidio se ha planteado la posibilidad de crear una fiscalía internacional que en fin, pues investigue e impulse investigaciones y enjuiciamientos por estos delitos y también eventualmente una posible competencia complementaria de una Corte Penal Internacional de Medio Ambiente, no la CPI actual con sede en La Haya, así lo he entendido desde luego, pero sería desde luego un organismo bastante próximo en estructura y en competencia y desde luego en cuanto a la complementariedad que informa la Corte Penal Internacional. En fin, me callo y tiene la palabra Marco Colacurci. Muchísimas gracias.
Okay, yes, I will speak in English, and first of all, I would like to thank Professor Nieto Martin, Professor Roy Zapatero for the great opportunity of being here today. It's an honor to share the panel with such prestigious speakers, and so I'm very excited of being here today. And dealing with the Convention on Ecocide, which represent one of the outcome of the international research group led by Professor Neret, I will deepen in particular the Convention Ecocide, not the one on Convention Eco-Crimes, but I've decided to take the moves briefly from a quite recent case represented by the International Monsanto Tribunal, because I think that this case it's interesting under multiple perspectives for our debate. And in particular, it is an attempt to condemn a multinational enterprise for the crime of ecocide, and it is at the same time a call for the introduction of this international crime, so at the international level. And it was an opinion tribunal, and we know the importance of opinion tribunal for the advancement of international law, because it was a case for the establishment of a shared truth, a truth which is often occulted at the local level, especially with environmental crimes, because we know the characteristic of this crime, but also for the often deceptive activities of multinational enterprise. Professor Delmas-Marty recalled the Exxon case, but Monsanto was also condemned for having violated the freedom of scientific research. So this is the imbalance in the power of knowledge between corporation and victims and enforcement agency. And finally, I think this case has symbolic importance because Monsanto was condemned also for complicity in war crimes for the action pursued during the Vietnam War. And we know that debate about ecocide arose in relation to the Vietnam War, in particular for the use of Agent Orange, an herbicide which was spread on the forests where Viet Cong were hidden. And so having now the multinational enterprise condemned for those acts and also for current acts, I think draw a red line between the historical origins of the debate and the current debate. However, I will use this case just as a starting point to deepen into the Convention on Ecocide, because as said, the establishment of an opinion tribunal represent a movement of social control by civil society as to overcome the lack of protection arising from national states and from international organizations. So it contributes to the process of self-awareness on the condition of victims experienced by the people affected by harmful conducts by multinational enterprise. And although recent legislative trends in the last 20 years have provided for a more participation of victims within the criminal proceedings, victims of corporate crimes still remain in the shadows. This is for multiple reasons. Surely for the nature of environmental crimes, because of the long latency period for having the consequences manifested for the obscure causal link, but often, especially when the offender is a corporation, for the imbalance of power. An imbalance of power about a monetary perspective, about political perspective, reputational perspective. But what is addressed within the Monsanto Tribunal is the imbalance in the power of knowledge. So multinational often has more knowledge than the national states, the control agency, the enforcement agency about the consequences of their product. And in the case of Monsanto, it was accused to put in place for a long time deceptive activity. And in particular, it is related to suborning false scientific report to took silence to scientific reports underlying the harmfulness of their products, to forcing or bribing local governments to approve the Monsanto product. And this is significant because the current conducts of Monsanto under scrutiny related to the use of the Roundup, which is the most sold herbicide in the world, in combination with some genetically modified seeds. So we know that Roundup contains glyphosate, which is suspected to have carcinogenic effects, and also that GMOs are highly controversial because they could affect human health and also biodiversity. And the Tribunal Monsanto assessed that there is no scientific consent about the harmfulness of this product, but Monsanto is also found guilty for violation to the right to health, human health, healthy environment, and the right to food because of this conduct was reconnected to the deceptive activity of Monsanto Tribunal. Evidently, this operation is possible only within an opinion tribunal, which acts outside the boundaries of criminal law and criminal procedure, because the proof of the harmfulness of those products, it's not beyond any reasonable doubt. But however, we know that opinion tribunal aim to alert the public opinion about the risk of some behavior. Another aspect I think it's interesting reading the final advisory opinion redacted by the Tribunal Monsanto is the legal framework reviewed and employed by the Monsanto Tribunal. Before we heard about the Global Pact for the Environment, so that it hopes to create binding instruments for state and for non-state actors. And this is precisely underlined by the Monsanto Tribunal, which employs the standard within the guiding principles on business and human rights, the so-called Ruggie principles, but we know that those principles do not provide for binding obligation upon corporation and non-state actors. And Professor Ruggie himself put under evidence that those principles were a first step in the building of binding obligation towards corporation. At the same time, we know that the guidance principle, the Ruggie principle, adopted and fostered the corporate compliance paradigm. So the responsibility to respect human rights for corporation comprehended a policy commitment to meet their responsibility to respect human rights, and most of all, a human rights due diligence process to identify, prevent, mitigate, and account for they address their impacts on human rights, and also processes to enable the remediation to any negative consequence on human rights. And we will see how the Convention on Ecocide deal with the corporate criminal liability and the corporate compliance paradigm, because although we know that the compliance paradigm enable a partnership between the public and the private, we also have assisted to a criminalization of compliance, so the need for harsh sanction and obligation on corporation are needed. So we arrive to the final question that the judges of the Monsanto Tribunal have to answer to, and so they found the liability of Monsanto for ecocide if it were introduced at the international level. But this is just mostly a call for the introduction of this crime. The tribunal does not provide for a specific definition of this crime, and so that's I think the continuity with the analysis of the draft convention on ecocide, because once arise the need for an international crime of ecocide, we can now take advantage of a coherent proposal which also has a broad approach, and so an approach we will see that deals also with the question left on the field by the experience of the Monsanto Tribunal. And so just a few words about the broad approach of the research proposal, because it is focused on the prevention, on the remediation, and obviously on the assessment of environmental crime at international level. We know that criminal law has a pivotal role within the research project, but also because it took the moves from the recognition that at national level mostly we do not have crime but administrative sanction, and also at supranational level we have few offenses directed to punish harmful conducts to the environment. However, we can see two different movements of criminal policy within such proposal, a simplification of the environmental criminal law, and, as Professor Delmas Martí said, an internalization of the environmental protection. On the first end, the simplification involves also a decriminalization process directed to limit criminal law only to serious violations, so leaving the field to administrative sanction where sanctions are just materials or subsidiary, and at the same time the proposed convention aims to rationalize the criminal and administrative sanction whose severity should be determined on the basis of the gravity of the crime and the correct individuation of the value protected. The internationalization of environmental protect instead, which obviously arises from the awareness of the insufficiency of single state protection, have led to the two different draft conventions on ecocide and ecocrime. One is characterized for an harmonization of crime at the national level, fostering the cooperation between jurisdictional authorities, and one instead pursue an unification of the supranational crime of ecocide. And so the criminal law, as noted before, is called to a triple transformation in a universalistic way, so to the need to universalize the reprobation, and internationalization of criminal law in the cooperation between states, and also in an anticipatory way, so to adapt the precautionary principle also to criminal law. And one thing has to be said in relation to the choice to adopt a convention of criminal cooperation also for a supranational crime of ecocide, because although this is quite common with reference to transnational crime, in relation to supranational crime whose customary character is not already recognized, this can appear innovative and not so common. But this choice, as the researchers who contributed to the project explicitly note, is directed to foster the debate at the national level about the notion of ecocide. So it is to give to national state a material on what to debate. So that's the choice, to have a supranational crime, but which is disciplined within a convention. Obviously, the supranational character of the ecocide led to universal jurisdiction, the absence of statute limitation, so all the characteristics we know about those kind of crimes. But the need to have a convention for its recognizing at the national level is in a prospective way to foster the debate. So now arriving to the contents of the Convention on Ecocide, the first point is to talk about the definition of eco-crime, and this choice was strictly related to the value to protect. We know that when we talk about environmental protection, different values are entangled. So the protection of human health, of biodiversity, of ecosystem. And we could also provide for different type of crime, humanicide, geocide, biocide. The choice instead of the research project went for the safety of the planet. So it is a broad concept, a matrix concept, which encompasses the violation, the affection of different values. But talking about the safety of the planet, it's not satisfactory in itself, because we can also have a contraposition between an anthropocentric and a naturalistic concept of the safety of the planet. So we are protecting the planet for itself, for future generation, or we are protecting the planet as the living context of human being. And as we already heard, the choice went for a naturalistic concept of the safety of the planet. And for this reason, criminal law is called to exercise its imaginative forces to prevent the most serious crime which can affect the durability of the planet. So Article 2 provides for ecocide as a crime in relation to intentional acts committed as part of widespread or systematic action and which affects the safety of the planet. And at the same Article 2, we have a list of behavior which can affect the safety of the planet. But after this list that we have seen, it's related to damages to human health, to fauna, to flora, to ecosystem. We have an analogy at the end of this list for what Article 2 punishes also other acts of similar nature committed intentionally and which affect the safety of the planet. And so we know that this kind of analogy clauses are useful to let the law protect also in relation with future acts that we don't already know about their harmfulness. So in this way, criminal law exercise is anticipatory function, and the precautionary principle is in some way integrated within criminal law, but it is otherwise a technique also well known at the international level, as we can see reading Article 7 of the Rome Statute. So still looking at the actus reo of the ecocide, Article 2 illustrates also the consequences that the act must cause. So an extensive, long-term and severe degradation of the air, of the atmosphere, soils, waters, aquatic environments, fauna or flora, or their ecological function. And on the other end, death, permanent infirmities, or serious incurable disease to a population, or the permanently dispossession of lands, territories, or resources of population. So also this is a well-known technique at the international level, as well as it is the reference to the mental element. So those acts must be committed intentionally, and the author should know that those acts are part of a systematic action that attempts to the safety of the planet. So this is also coherent with Article 30 of the Rome Statute, but there is a dilatation of the notion of intent, because Article 2 also provides that acts are also considered intentional when their author knew or ought to have known that there was a high probability that they would affect the safety of the planet. And so this choice, it is in relation for the fact that often environmental crimes are related, mostly are related to economic crimes. So the first purpose is profit, not to damage the safety of the planet. And so to avoid at the jurisdictional level a dilatation of the notion, Article 2 already provide for an overture about a dilatation of this concept. However, we will see that for gross violation, also the Convention of Eco-Crimes provide for the liability. But what it is probably one of the most interesting aspects of the draft convention on ecocide is the fact that it provides for the liability of both natural and legal person. And we will see that corporations play a central role within the convention, because we know that especially transnational corporations are often the author of such crimes, but also there is the awareness that corporations are the organization that have the means to provide for the remediation of the crime. So the failure, the closure of the corporation is limited to residual hypotheses, and instead a cooperation between the public authorities and corporation is encouraged to reach, to have remedial activities. So as it has been noted, although the catalog of sanction to natural person and legal person mostly overlap, we can see that they pursue different aims. Sanctions against individual persons are directed to general prevention, deterrence. Instead, when we look at the sanction against corporation, the most important aim is remediation, to put remedy to the damages of environmental crime. So we can see that the draft convention adopt a corporate compliance idea. This is starting from the criteria of liability of the corporation, which are based not only on the identification theory for what the liability arises from the commission of the crime by an individual put a high level within the corporation, but also according to the organizational fault model. So when a failure in surveillance or control made the commission of the crime possible. We know that corporate compliance solicits the cooperation between the corporations, so we can also talk about reactive fault of corporation. But just reading at the catalog of sanction, we can see how the cooperation is encouraged. In particular, we have an innovative form of sanction together with the seizure of the income of the crime, which probably represent the most effective form of contrast to economic crime. We have fines, we have interdiction, we have shaming sanction, the publicity of the condemnation, but we also have the appointment of a corporate monitor, of an external monitor, which has the duty to look after that the corporation put in place remedial activities and compensate the damages. And it is significant that within the list at Article 7 of sanction, we have both sanction and remedial activity listed, and the appointment of a corporate monitor, it is the last sanction before the remedial activity, because I think this sanction, it is at the crossroad between repression and remediation. And another aspect that underline these tendencies is the fact that if the penalties could endanger the solvency of the corporation, the security of the job, or the reparation of the damages, staggered payments are permitted. And also that the dissolution of corporations, so the most serious form of incapacitation of the corporation, interdiction of the corporation, can be applied only in case the corporation was created with the sole purpose to realize the crime, or it is considered to be part of a criminal organization. So dissolution of corporation is a very residual hypothesis. As said, the remediation is highly encouraged, but what do we intend in this convention for remediation? This is a broad notion, because the remediation aims to the ecological restoration of the damaged ecosystem, but also to the restoration of victims. So if we saw within the Monsanto Tribunal case that victims are often put on the side, having a system which aimed to remediation give victims a more important role. In particular, it is significant that together with the compensation of damages, reparation can assume also symbolic forms in relation to the cultural nature of the crime. So corporation can ask to apology to the injured communities. However, remediation can also go further. So it can consist in the fund of the global environmental facility in order to help the investments for environmental protection at the international level. And it can also consist in the putting into place of measures to help the local development. If this is a restoration which act outside the corporation, obviously the corporation have also to modify inside. So remediation is also to adopt compliance programs adequate to prevent the future commission of analog crimes. So the remediation, as we can constate, as a broad meaning and a broad aim. And as said, cooperation is really fostered, is highly encouraged. At Article 8 in the selection and determination of sanction, priority criteria is the compensation of damages and remedial activity. And also, if on the one hand, the reiteration of the crime, the absence of adequate international measure of surveillance and control, and obviously the high profit are considered as aggravating factors, instead the immediate compensation of damages and support to the victim, the immediate adoption of internal compliance programs, and the cooperation with the authorities in the assessment of the liability are considered mitigating factors. So cooperation is highly encouraged. However, the difference between the Convention on Eco-Crimes and ecocide is that for ecocide, given the heinous nature of such crime, forms of suspension or non-prosecution against corporation are not permitted. So the fair prosecution agreement, non-prosecution agreement are not permitted for ecocide. But I think an interesting trait of the sanction system against corporation is that also for this serious crime, the cooperation is fostered, and this is obviously a pragmatic approach. Other 2 points that I would like to underline within the Convention, if we saw that for the Tribunal Monsanto arose the need to have an international and independent tribunal. In this sense, the Convention encourages the establishment of a new international criminal court for the environment. And in this sense, the project explicitly recalls the experience of the opinion tribunal in the aim to have a shared truth. But the Convention is also aware of the need to not having a multiplication of jurisdictional institutions at the international level. So it proposes a new international court for criminal court for the environment with its own statute, but it should be operate using the actual structure of the ICC, and the judge of the ICC should be the judges of the International Criminal Court for the environment. But the need to have 2 different courts arose especially to mark the difference between the protection of the environment, so the ecocide, and on the one side, and the crime against humanity on the other side. Alongside with an International Criminal Court, also an international prosecutor for the environment is proposed. And in particular, it is imagined a first phase of action of this international prosecutor for the environment, because it should have power of coordination and to share information because local enforcement agency. And again, the experience, the European experience can be considered useful, because as well as Eurojust served as a test track for the European Public Prosecutor's Office, the project imagined that this first establishment of the international prosecutors for the environment could serve as a test track for a true international public prosecutor. But this is postponed when the condition for the institution of the International Criminal Court will be met. And finally, alongside with the institution of jurisdictional international institution, we have also the proposal for the Green, so an independent group of research. In this sense, the convention addressed also the lack of freedom in scientific research, and so it proposed to have a group of independent scientific researchers which can have a role in sharing the knowledge, in studying, in researching, and in disseminate the result about the conducts that can amount to environmental crime and ecocide. And so I've tried to underline the points emerging from the Tribunal Monsanto that I think it was useful for the convention. Thank you.
Thank you very much, Marco.